Hello and welcome to Indianomics. The hot topic today is the recent amendment to the Insolvency Resolutions Regulations. I'm Lata Venkatesh. With me are a panel of top legal experts and bankers of the country. Most importantly, we have with us the Chief of the Insolvency and Bankruptcy Board of India, Mr. M.S. Sahu, from whose office these amendments have originated. But first, let us look at the amendments to the Insolvency and Bankruptcy regulations. The board has amended these regulations, the resolution process, to force bankers to back the most credible resolution plan. The amendments mandate that the resolution applicants have to disclose their associates and subsidiary companies and also any criminal proceedings or disqualifications under the Insolvency and Bankruptcy Act. Legal Eagles told us that these amendments seem to hint that bankers should not just look at the quantum of haircuts that they have to take, but should rather concentrate on the sustainability of the plan. Well, we have with us a whole host of legal luminaries to tell us exactly what this amendments actually suggest. Let me introduce my panel. I have with me Mr. M.S. Sahu, the Chief of the IBBI, the Insolvency and Bankruptcy Board of India. Also joining me on the show is Mr. R.K. Bansal, former Executive Director, IDBI Bank, Behram Vakil, Partner at AZB, and Rajendra Chitale, Partner, Chitale Legal, and Mr. Uday Bansali of Deloitte. Thank you very much, gentlemen, for joining me. First, let me invite Mr. M.S. Sahu. Mr. Sahu, can you interpret to us what was the purpose behind these amendments?
See, we are talking about resolution of insolvency of a corporate. And by definition, we know a corporate exists forever. And our objective is that we resolve the insolvency in such a manner that we maximize the value of assets of this corporate debtor so that this corporate debtor continue to exist as a legal person in perpetuity and keep on serving the stakeholders. Please remember that corporate, though it deals with or it starts with the money of debtors and equity holders, there are a large number of stakeholders having interest in the corporate. Okay. The law is designed in such a manner that the very first endeavor is resolve the insolvency that maximizes the value. And only when we conclude that resolution is not possible, the liquidation maximizes value.
No, Mr. Sahu,
so our aim is that the corporate should succeed. Corporate should succeed post resolution.
No. So what? Exactly. Correct. So what you're saying is that you don't want that company to come back to you with a problem, with a stress again. It should be resolved in such a way that it becomes sustainable. Now the immediate question therefore is, suppose you have one party telling the committee of creditors that you have to cut the debt by half, then I will make it sustainable. And another party saying you take off 20% of the debt, correct, I will service 80% and I'll make it sustainable. For the creditor, obviously the guy who is taking 80% of the debt is the more attractive option. But you are saying they should not go by the haircuts.
No, what I am saying is that let us be realistic and look at the efficiency level of the resolution applicant. Okay. People in marketplace, when market is competitive, people have different levels of efficiency. With one level of efficiency, one kind of business model, one kind of product combination, one may be able to give 50% haircut, another may be able to give 20% haircut. But it is a business decision of the committee of creditors. Okay. So committee of creditors are looking at how realistically the plan has been drawn up. Is it actually grounded? Does it actually take into account this, for example, market situation, the technological situation, as well as the capability of the promoters of the resolution applicant, those who have to implement this? If they are not credible, how can we entrust a company to them?
Okay. No,
if the company has to continue to exist, it must be in the hands of desirable persons.
Okay. Well, Mr. Sahu, just stay on. Let me toss this to Behram. Behram, if you go by what Mr. Sahu is saying, that, the record of credibility, then already the promoter who has come does not have a record of credibility. That is why the asset is stressed. So can we interpret that the promoter will be, the existing promoter will be second or third in line, and those who have not been NPAs will have ought to be the first choice according to these regulations?
No, thank you very much, Lata. In fact, I think that unfortunately real life is much more complicated.
Okay.
Because in the example you were giving, on the haircut, say one gives, let's not make it too stark, but say, say 50 and 65.
Okay.
Then it's also, there has to be the NPV calculation. There has to be how back-ended it is. And then as Dr. Sahu's press release and the changes that were very recently made say that we have to look at the credibility and the creditworthiness. So the creditworthiness goes to the fact that if it's back-ended its payment over several years, then are those really going to come? Forget the NPV part of it. Will it really fructify? And the second part of it, so the regulations really are in two parts. One is the creditworthiness. So it talks about the capability of the bidding entity to meet its financial commitment. And the other is the credibility, which really talks about malfeasance, fraud, disqualification, the history of the past to show, because after all, again, as Dr. Sahu says, we want this to run efficiently and profitably going forward.
Okay.
So are these the right steering wheels for the future? So that's the two parts, and that's what these regulations have sought to do.
Okay. All right. Now, let me then take the disclosure part. See, must disclose details of preferential transactions under Section 43 of IBC, must disclose undervalued transactions under Section 45 of IBC, must disclose extortionate credit transactions, must disclose fraudulent transactions. Now, obviously, willful defaulters are obviously cannot be given back the company. But the IBC candidates, the prominent ones who are in the NCLT, Rajendra, are people who are perhaps running other businesses properly. What do you make of all these disclosures? Does this put any of the promoters at a disadvantage?
Well, I don't think that anything is specifically targeted to a particular type of resolution applicant. I think it is an important test which has been put on the quality of the resolution applicant and how to measure the qualities of, if this test is not passed, then there is an issue for the creditors committee to resolve in terms of whether this applicant is good enough.
But credibility is just an adjective. How would you break it down into concrete tests? They should not have had any NPAs. How will you break it down?
I think finally this is going to evolve, but finally, if you ask me, at the end of the day, from a creditors committee perspective, it is eventually about determining the true value of the recoverable amount that they will get out of all this. Now, think of it like this, that if the creditors were to take a view that I am finally taking a counterparty risk on the resolution applicant, and therefore for me, irrespective of the fact that the minimum credentials have to be satisfied in terms of conduct, it's important to understand the credit rating of that applicant in terms of determining my expected rate of return at which I will want to discount the cash flows, assuming that the cash flows are resilient enough and can be realized.
No, credit rating of the applicant is one thing, but credit rating of that product, because the applicant himself may be very good, but if he promises, a very higher debt compared to another applicant who is promising to take only a lower debt, Uday, how do you think it will work? Do you think, as an IRP, you will put a promoter, under a lower standing simply because of record, credibility as a record is low?
See, Lata, in a sense, what this circular has done is formalized a lot of thoughts that were already and ideas which were being bounced around by lending circles and people who have these exposures to these companies. So in a sense, the bar has been raised, and it's going to be incumbent upon a promoter to put forward a vastly superior plan, to stack up with other applicants, say other things being equal. So in a sense, it's kind of formalizing the process. Now, it's very difficult to quantify this. As Rajendra said, it's a credibility and, credit worthiness issue. So ultimately, what's the whole package stacking up? And this is a judgment call of the COC eventually. And these are factors that the COC has to consider.
Okay.
I think that's what's really coming.
Okay, let me get to the banker. Mr. Bansal, do you think after looking at these regulations, the Committee of Creditors, largely bankers, will feel obliged to not look at the highest haircut, or rather the lowest haircut, but actually look for the sustainability of the business? Will they be really able to take that call? Or do you see them taking that call?
Yeah, certainly. I think other speakers, what they have said, it makes sense for the Committee of Creditors to look into all this. See, the only criteria which is being discussed is that credentials and credibility of the bidders has to be looked into. Whether it is an existing promoter or not, that's a different issue. But yes, one view which was being expressed earlier was that existing promoter discounting rate could be slightly high because his rating would be low. So based on the discount value, we can calculate the NAV.
Okay.
So certainly final call will be based on this only, that who is giving us lowest haircut.
Mr. Sahu, that was my fundamental question as well. Okay, I'll do one thing. We'll take a break. We'll come back and probably we will have our guests reconnected. We are back in a minute. This is a very crucial question. Is the dice loaded against the promoter, or does the promoter have as equal a chance as anyone else to buy back his company from the NCLT process? That's the question we will be asking in a minute with our guests.